So in 1896, a former slaveholder became literally the only man in the United States government fighting to save black civil rights.
Yeah, which is it's just a massive paradox to wrap your head around.
Right. I mean, let that sink in for just a second. Welcome to the deep dive, everyone. Today, we're opening up a dossier that tracks a really wild timeline. We are looking at how the Supreme Court, over a span of just 13 years, took the law and completely dismantled the architecture of equality in America.
It's a really sobering deep dive today.
It really is because, you look at this historical whiplash. You have the 14th Amendment ratified in 1868, and it was designed to promise equal protection and full citizenship to formerly enslaved people.
Right, it was the new foundation.
Exactly. But then by 1896, that exact same amendment was being used to provide constitutional cover for racial segregation.
Yeah. And to understand how that happened, we're going to focus on this really pivotal window between 1883 and 1896. Our sources today anchor on two monumental decisions. So the civil rights cases of 1883 and then the infamous Plessy v. Ferguson decision in 1896.
Right.
And we are going to soberly, chronologically, unpack the legal reasoning on both sides. Not just looking at the majority opinions, but examining the famous lone dissents of Justice John Marshall Harlan. And our goal here isn't to, just look for villains. It's to understand how these justices acted as men of their particular moment in time.
I really like that approach because when you and I think about constitutional law, we usually picture something rigid, like a grand building.
Right, yeah.
You pass an amendment, you build this massive fortress for civil rights, and it's written in stone. But the sources we're looking at today show how these judges basically walked up to that fortress, looked at the blueprints, and just started arguing about definitions.
Yeah, that's exactly
So they didn't bulldoze the building. They just redefined what a wall was and what a door was until the people inside realized, wait, we are completely exposed to the elements here.
It is a perfect architectural metaphor for what occurred. Because they didn't erase the 14th Amendment from the text of the Constitution. They just systematically redefined its scope. Right. But to understand why they started dismantling it, we first have to understand the ground they were building on. We have to look at the cultural and political mood of the 1870s and 1880s.
Okay, yeah, let's start there. Because judges don't operate in a vacuum. So walk me through that environment. We are, barely a decade out from the Civil War?
Barely a decade, yes.
The North won, slavery is abolished, the Reconstruction Amendments are on the books. What shifts in the culture?
Well, what shifts is a profound national exhaustion. And this culminates in the Compromise of 1877, which is basically the mechanism that ends military reconstruction in the South.
I know that compromise was a massive turning point, but how did it actually play out? Like, was it a formal treaty or something?
Oh, no. No, it was a deeply pragmatic, backroom political deal. So the presidential election of 1876, this was between Rutherford B. Hayes, the Republican, and Samuel J. Tilden, the Democrat, was fiercely disputed.
Right. I remember reading it. It was super close.
Extremely close. Several southern states actually sent in rival electoral certificates. The nation was totally paralyzed, and there were genuine fears of renewed armed conflict.
Wow.
Yeah. So to resolve the crisis, a commission was formed and a compromise was reached. The Southern Democrats agreed to concede the presidency to the Republican, Hayes.
Okay.
But in exchange, they demanded that federal troops be withdrawn from the remaining southern states.
And wait, those federal troops, they were essentially the only enforcement mechanism keeping those Reconstruction governments afloat, right? Like, they were the only ones protecting the civil rights of black citizens.
Exactly. So without the troops, the federal government was signaling a full retreat.
Ah, I see.
And if we connect this to the bigger picture, this wasn't just a reluctant political concession. It reflected a much broader cultural shift. By the 1880s, Northern Republicans, who had been the primary drivers of abolition, they had just largely moved on.
We moved on to what?
Economics, mostly.
Yeah.
Railroads, industrialization, westward expansion.
So it was really just fatigue. Like, they fought a massive war, they passed the amendments, and then they just decided they were tired of dealing with it.
Fatigue is exactly how the sources describe it. The historical reality is that the so-called reunion between the white North and the white South was essentially purchased at the expense of black Americans.
Man.
Yeah, the white population of the country just decided it wanted to heal the sectional divide to do business together again. And the agreed-upon price for that healing was abandoning the enforcement of the rights of the freed people. The North basically looked at the South and said, We'll let you handle your own racial
Okay,
affairs.
wait, I have to push back here, though. Because I understand the political deal-making. Politicians compromise every day.
Right.
But giving up culturally is one thing. How do they get away with it legally? I mean, the 14th Amendment is sitting right there in plain English. It guarantees equal protection. We're always taught that the Supreme Court is this dispassionate, neutral arbiter sitting way above the dirty politics. So how does a cultural mood dictate their formal, binding legal rulings?
That tension is basically the central mystery of this entire era.
Mm.
And the short answer is that the court did not invent the racial consensus of the 1880s. They ratified it.
They ratified it.
Yes. The justices were human beings. They were drawn from the elite classes of that specific cultural context. And what they did was translate a cultural and political settlement into formal constitutional doctrine.
But how do they do that without looking like they're just, ignoring the actual Constitution?
By using highly technical legal logic. The text of the 14th Amendment clearly pointed toward equality.
Right.
And gave Congress the power to enforce it. But the court took the era's retreating cultural consensus, this national desire to just stop intervening in the South, and they read that consensus into the text of the Constitution. And, crucially, they presented the resulting decisions as neutral, inevitable, almost scientific law.
So they use the language of strict objective law to justify what is actually just the political mood of the time?
Precisely. It is a masterclass in how legal doctrine can be shaped to the social reality while pretending to be completely separate from it.
Okay, let's see exactly how this machinery worked in practice then. Because to understand how this consensus became a law, we have to look at the first major blow to that fortress. Let's get into the civil rights cases of 1883.
Yeah, this is where the dismantling truly begins. And to understand the shock of this ruling, we have to look at the law they were striking down, which was the Civil Rights Act of 1875.
Right. Our sources call this the boldest use of congressional power at the time. So walk me through the lived reality of this law. What did the 1875 Act actually do for an average person?
It was incredibly progressive. It was a federal law that made it a crime to deny full and equal enjoyment of public accommodations based on race.
Public accommodations meaning what exactly?
We are talking about inns, public conveyances on land or water-so trains, and boat theaters, places of public amusement.
So Congress is explicitly saying, we are using our power under the 14th Amendment to guarantee that if you are a black citizen, you can walk into a hotel in New York or ride a train in Louisiana or buy a ticket to a theater in Ohio, and you cannot be turned away because of your color.
Exactly. It was a real attempt to secure the daily, practical reality of equal citizenship. It recognized that freedom isn't just about, not being enslaved. It's about being able to move freely and participate in the public economy without humiliation.
Okay, so that is the law of the land in 1875. Fast forward to 1883. A series of cases regarding this exact law makes its way to the Supreme Court.
Right, they bundle them together.
They group them as the civil rights cases. And the court strikes the law down. They rule that the public accommodation section is unconstitutional. And the vote, this is the crazy part, the vote is 8-1.
8-1. It was a near unanimous rejection of federal power, and the majority opinion was written by Justice Joseph P. Bradley.
I want to look closely at Bradley. What's his background? Because honestly, you hear that ruling and you assume he must be some diehard Southern sympathizer.
You'd think so, but not at all. Justice Bradley was a Northerner.
Really?
Yeah, he was from New York, appointed by Ulysses S. Grant, who was a Republican. Bradley had actually been a really strong Unionist during the Civil War.
Oh.
But by 1883, he just perfectly embodies that Northern exhaustion we were just talking about.
So how does a Northern Grant-appointed justice dismantle a civil rights law? Like, what is the specific legal mechanism he uses?
Well, Bradley creates a doctrine that actually remains a cornerstone of constitutional law to this day. He drew a tremendously sharp, formal legal distinction between the acts of a state government and the acts of a private business or an individual.
Okay.
He looked really closely at the wording of the first section of the 14th Amendment. The text says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws."
No state shall. Okay, I think I see where this is going.
Yeah, Bradley zeroes in on those first two words, no state. He reasoned that the 14th Amendment is strictly prohibitory upon the states. It only forbids state action.
So he's saying the Constitution is basically a set of handcuffs, but they only fit on the wrists of government officials.
That is exactly his logic. He reasoned that, individual invasion of individual rights is not the subject matter of the amendment. Therefore, if a private hotel owner in New York or a private theater owner in Ohio decided on their own to put up a whites-only sign, they were acting for themselves. As private citizens, they were not acting as the state.
Ah, I get it.
And because there was no state action, Congress had absolutely no constitutional authority to reach them or regulate their behavior.
I want to make sure I'm fully grasping how wild the real-world implications of this state action doctrine are. Let me try an analogy here.
Go for it.
It sounds like they're saying, if a city police officer stands in front of a theater and physically blocks you from going inside because of your race, that's illegal state action. The 14th Amendment stops that.
Correct.
But if that same police officer just steps back, leans against his cruiser, and just watches every single private bouncer at every single business in town block you from entering, the Constitution just shrugs its shoulders. It basically says, hey, that's just private individuals doing private things. Is that essentially the distinction?
Your analogy captures the exact functional reality of the ruling.
Yes.
The court created this massive zone of private behavior that the federal government was suddenly entirely powerless to police.
Man!
That architectural fortress we talked about, Bradley just pointed out that the 14th Amendment only built walls against government abuse. It left the roof completely wide open to private discrimination.
But wait, the lawyers defending the law, they didn't just rely on the 14th Amendment, did they? Didn't they also bring up the 13th Amendment, the one that actually abolished slavery?
They did, yeah. And their argument was actually quite compelling. The 13th Amendment doesn't have a state action requirement at all. It just says slavery shall not exist.
Right, there's no state shall in there.
Exactly. So the lawyers argued that banning someone from a public inn or a train based solely on their race was a lingering badge or incident of slavery. It was a social practice designed specifically to enforce the old racial hierarchy of the slave system.
Which seems historically obvious, right? Like, you don't get widespread racial segregation in 1883 without the preceding 2 centuries of race-based chattel slavery. They're obviously linked.
It seems obvious to us, sure. But Justice Bradley completely rejected that argument. And this is where we see a piece of rhetoric from the majority that is truly jaw-dropping.
Oh, boy.
Yeah, Bradley insisted that being refused a seat in a theater was just an ordinary private wrong, not a badge of slavery. He wrote that you can't equate every act of discrimination with slavery. And then he pens this sentence that just reveals the entire psychological fatigue of the white North.
What did he say?
He wrote, when a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws.
Wait, let me process that. The special favorite of the laws?
Yes.
In 1883, it had been barely 18 years since the Civil War ended.
Yeah.
You have centuries of generational chattel slavery, a catastrophic civil war, a brief window of military protection, and before 2 decades have even passed, a Supreme Court justice looks at a black citizen trying to book a hotel room and says, "We've helped you enough. Stop asking to be the special favorite."
It's a profound and honestly devastating window into the mindset of the era. The court was framing the demand for basic, equal access to society not as a fundamental right, but as a request for special treatment.
Which, by the way, is a rhetorical trick that is still incredibly prevalent today. Whenever a marginalized group asks for equal footing, the dominant group often reframes that request as a demand for unearned privilege.
Precisely. The court was formally declaring that the period of federal intervention, the whole era of Reconstruction, was definitively over. The federal government immediately lost the power to police private discrimination.
So what was the practical effect on the ground, say, for a black family traveling in 1884?
The practical effect was just an immediate hardening of segregation across the whole country. Without any federal protection, black citizens were left entirely to the whims of local private business owners.
That's terrifying.
And the federal government would not regain the specific authority to police private public accommodations until the Civil Rights Act of 1964.
Oh my God. So this one court decision, built on this highly technical legal distinction between state and private action, created an 80-year void in civil rights. 80 years.
Yeah, 80 years of Jim Crow.
But you mentioned earlier the vote was 8-1, which means we need to talk about the one,
Well,
who is the single justice in 1883 who looked at this massive national consensus, looked at the rest of his colleagues, and said, no, you're all wrong.
that was Justice John Marshall Harlan.
And this is where the dossier gets fascinating to me, because Harlan breaks every stereotype you might have. If you picture a fierce lone defender of civil rights in 1883, your mind probably goes to some radical, fiery northern abolitionist, someone who had been fighting this fight since they were a teenager. But I'm looking at our notes on Justice Harlan, and it says he was a former Kentucky slaveholder.
He was, yeah. It is one of the most incredible biographical arcs in the history of the court. Harlan was actually born into a very prominent slaveholding family in Kentucky.
Okay.
He opposed the abolition of slavery during the Civil War, even while he was fighting for the Union. He opposed the 13th Amendment. He even opposed the 14th Amendment initially.
Wait, I'm so confused. How does a guy who actively opposed the Reconstruction Amendments become the only guy willing to defend them on the Supreme Court? What caused the shift?
It was a really gradual evolution, and it was driven by stark reality. After the Civil War, Harlan returned to Kentucky, and he just watched the rise of the Ku Klux Klan and these white supremacist vigilante groups.
Okay.
He saw the sheer, unvarnished violence being unleashed on freed people. And as a man who fundamentally believed in the rule of law and order, he was absolutely horrified.
So it was a law and order thing.
Yeah, he realized that without a strong federal government willing to enforce the law, the states would just allow mob violence and terror to rule. He eventually recognized that the Reconstruction Amendments were, quite literally, the only legal tools available to protect basic human life and order in the South.
So it wasn't necessarily this spontaneous, emotional, moral awakening. It was an evolution rooted in just witnessing the bloody reality of what happens when the federal government steps back.
Exactly. And because of that journey, when he looked at the Civil Rights Act of 1875, he didn't see an abstract theoretical debate. He saw a necessary practical tool.
So how did he dismantle Justice Bradley's legal logic? How did Harlan attack this whole state action doctrine?
Well, Harlan went straight for the core premise of Bradley's public versus private distinction. He argued that the majority was totally mischaracterizing what an inn or a railroad actually is.
How so?
Bradley said they were just private individuals doing private things. Harlan completely disagreed. He argued that these entities actually perform public functions and operate under public licenses.
Okay, break that down for me. What does he mean by a public function?
So Harlan pointed out that a railroad corporation doesn't just spring up out of nowhere, right? It requires a charter from the state. The state grants the railroad special privileges, like the power of eminent domain to take land and lay down tracks.
Right, they get government perks.
Exactly. So the railroad is acting as an agent of the public highway system. And similarly, an innkeeper operates a public house. They are licensed by the local government to serve the traveling public.
I see. He's saying you can't call yourself a purely private business when you are heavily subsidized, licensed, and empowered by the state government. They're totally intertwined.
Precisely. They are quasi-public entities. And Harlan's logic was that because they exist by public grant to serve a public function, their discrimination can't just be brushed off as purely private behavior.
That makes a lot of sense.
Yeah, they are extensions of the public sphere, and therefore, they should be subject to the 14th Amendment's demand for equal protection.
That is incredibly modern legal reasoning. Like, he's looking past the technical label of private corporation and looking at the functional reality of how the business actually operates in society.
He was focused entirely on substance over semantics. In his dissent, Harlan explicitly warned that the court was sacrificing the actual substance of the Reconstruction Amendments to what he brilliantly called subtle and ingenious verbal criticism.
Subtle and ingenious verbal criticism. That is such a sharp critique. It's him calling out the majority for using fancy lawyer tricks to avoid the plain, obvious reality of what the amendments were meant to do.
He recognized that the 14th Amendment was written to secure real, everyday equality for freed people. The ability to travel, to secure a room for the night, to participate in public life, that was the substance of freedom.
Right.
And he saw his colleagues taking that real, tangible equality and reducing it to mere paper equality.
He's basically looking at the rest of the court and saying, you are using the rules of architecture to justify why it's perfectly fine that this building is actively collapsing on people's heads.
Exactly. But, as powerful as his dissent was, it was just a dissent. The law of the land was set. The 14th Amendment only applied to state action.
Which brings us to a massive structural question.
Right.
Because if the Supreme Court rules in 1883 that the federal government is powerless to stop private discrimination, what happens when a state government decides to drop the private pretense altogether?
Right.
Like, what happens when a state explicitly writes racial discrimination directly into its own state laws?
This is the critical transition from the 1880s into the 1890s, and it leads us directly to the orchestration of Plessy v. Ferguson.
Okay, let's set the scene in Louisiana. The year is 1890. The Louisiana state legislature passes the Separate Car Act, and this law legally mandated equal but separate railway cars for white and black passengers.
Yeah.
So the state is doing the discriminating here. It's an official state law with criminal penalties.
Yes, this is the very definition of explicit state action.
So if you are a civil rights advocate living in New Orleans in 1890, you look at this new law and you look back at the Supreme Court's 1883 ruling. The court explicitly said, we can't touch private businesses. We can only step in when it's state action.
Right.
So logic dictates that this new Louisiana state law must be wildly unconstitutional, right? Because the state is doing the exact thing the Supreme Court said the state isn't allowed to do.
That was exactly the strategic thinking of the civil rights advocates in New Orleans. And this brings us to one of the most fascinating mechanical aspects of our sources.
Yeah.
Because the famous incident that creates the Plessy v. Ferguson case wasn't just a random historical accident.
No.
No, it wasn't just a guy who happened to get on the wrong train car and got arrested.
Oh, this was highly coordinated, wasn't
It was a meticulously orchestrated test case. A group formed in New Orleans in 1891 called the Comité des Citoyens, or the Citizens Committee.
Okay.
This was an alliance of Creole and Black New Orleanians who came together specifically to organize, finance, and execute a direct legal challenge to the Separate Car Act.
So they were essentially laying a trap for the state government. They wanted to force an arrest under this specific state law to force the Supreme Court to strike it down based on that 1883 precedent.
Exactly.
And the person they chose to spring the trap was Homer Plessy.
Yes. On June 7th, 1892, Homer Plessy bought a first-class ticket on the East Louisiana Railroad, boarded the train, took a seat in the whites-only car, and was subsequently arrested.
But the sources note a really fascinating strategic detail about Homer Plessy. He was specifically chosen by the committee because he was described as being 7/8 white and 1/8 black. Like, his physical appearance was such that he could easily pass for white.
This was a highly intentional tactical choice by the committee.
But wait, how did the arrest actually happen then? If he looked white, how did the train conductor even know to arrest him? Did Plessy just stand up and announce, hey, by the way, I have black ancestry?
This is where the mechanics of the protest are just brilliant. The committee actually partnered with the railroad company itself.
Wait, the railroad was in on the protest? Why would they care about civil rights?
Well, they didn't necessarily care about civil rights, but they cared deeply about their bottom line.
Wow.
The railroad companies hated the Separate Car Act because it was incredibly expensive. It meant they had to buy, maintain, and haul extra train cars just to comply with the segregation law, even if those cars were mostly empty.
Oh, of course. It's a financial burden.
Exactly. So the railroads secretly cooperated with the Comité.
That is wild, the intersection of civil rights and corporate cost-cutting.
I know, right? And to ensure the arrest went perfectly according to plan, the Comité actually hired a private detective.
Wow.
Yeah. When Plessy sat down, the conductor who was in on the plan approached him. Plessy informed the conductor of his racial heritage and refused to move to the black car. The private detective then immediately arrested Plessy and charged him specifically under the Separate Car Act.
So they wanted a perfectly clean test case. They didn't want him arrested for disturbing the peace or vagrancy or anything. They needed him charged with violating the segregation statute itself. But I'm still stuck on why they specifically chose a man who was 7/8 white. What was the legal strategy there?
They were trying to attack the law on multiple fronts. By choosing Plessy, whose racial heritage was not visually obvious, they wanted to sharpen a profound legal question. Who exactly counts as black?
Oh, that's clever.
Yeah, who gets to decide? How can a low-level train conductor be legally empowered by the state to make instantaneous, binding, pseudoscientific judgments about a citizen's racial pedigree?
So they wanted to expose the absurdity of the state trying to categorize its citizens by race. They were pointing out that race isn't some clear biological binary you can easily legislate. It's a messy, arbitrary social construct.
Exactly.
And putting the power to define it into the hands of a ticket taker is just completely irrational.
Precisely. They were pointing out the inherent irrationality and the unworkable nature of the law. And to argue this complex case, the committee brought in a lead lawyer named Albion W. Tourget.
I'm looking at our notes on Tourget. He says he was a radical Republican, a former judge in North Carolina during Reconstruction, and a novelist.
Yeah.
How does a novelist end up leading the most important civil rights case of the century?
Tourget was a brilliant, multifaceted figure. His novels were incredibly famous at the time. They were essentially political thrillers about the failures of Reconstruction and the violence of the Ku Klux Klan.
Oh, interesting.
And because he was a storyteller, he understood how to frame a legal argument, not just as a dry technicality, but as a moral narrative.
And what was his specific legal narrative for this case?
Well, Tourget formulated the core argument that the Separate Car Act was unconstitutional. And in his brief to the Supreme Court, he coined a vital phrase that would echo through history. He argued that justice must be colorblind.
Wait, so it was Tourget, the novelist lawyer, who actually invented that phrase for this case?
He did. He argued that the government has absolutely no business knowing the color of a citizen's skin.
Okay, so the trap is sprung, Plessy is arrested. The local judge, John Howard Ferguson, upholds the state law, which is why the case is named Plessy v. Ferguson.
Right.
The comity appeals it, and in 1896, the case finally reaches the Supreme Court.
This is the moment of truth. 13 years after the civil rights cases, the court has an explicit state law mandating segregation. The state action doctrine should theoretically force them to strike it down.
And the ruling comes down, and Judge Ferguson's lower court decision is upheld.
Yep.
The Supreme Court says the Separate Car Act is perfectly constitutional, and the vote is 7-1.
7-1. With this ruling, the Supreme Court formally blesses the doctrine of separate but equal.
How? I honestly need you to walk me through the legal gymnastics here.
Right.
If the 14th Amendment was meant to stop states from denying equal protection, and Louisiana just passed a state law forcing people into separate train cars based on race, how does the Supreme Court justify saying that doesn't violate equal protection?
Well, we have to look at the majority opinion, which was written by Justice Henry Billings Brown. And like Justice Bradley before him, Brown was a Northerner. He was born in Massachusetts, educated at Yale and Harvard.
Interesting. Another Northerner.
Yeah. And you're right. Because of the 1883 precedent, Brown couldn't use the state action excuse. The state of Louisiana was undeniably acting. So he had to invent a completely new way to narrow the 14th Amendment.
So what was the new architectural loophole he found?
Justice Brown drew a distinction between different types of equality. He argued that the 14th Amendment was intended to secure legal and political equality.
Okay, meaning what?
That means the right to serve on a jury, the right to vote, the right to sue in court. But he claimed the amendment could not have been intended to abolish distinctions based upon color or to enforce social, as distinguished from political, equality.
Social equality. So he's saying that riding on a train or sitting in a waiting room is a purely social arrangement, and the Constitution just doesn't care about social arrangements.
Exactly. He framed segregation on trains as a matter of social preference. And furthermore, he argued that the Separate Car Act was a reasonable exercise of state police power.
Okay, police power. Let's translate that for you listening right now. When we hear police power today, we think of literal cops making arrests.
Right.
But in constitutional law, it means something broader, right? Like how a modern city uses its police power to enforce zoning laws, deciding where you can build a factory versus a house, or like health codes for restaurants. It's the state's basic right to regulate for the general health, safety, and morals of the community.
That's a great modern parallel. Justice Brown is essentially saying that it is entirely reasonable for a state legislature to look at its population, decide that mixing races on trains will cause friction or conflict, and use its zoning power, its police power, to separate them in order to maintain public peace and order.
So they use the threat of white racist violence as a justification for segregating black citizens. They basically say, well, if we let them ride together, there might be a fight, so it's safer for everyone if we pass this segregation law.
That was exactly the underlying logic. But Tourget and the comité had anticipated this. Their counter-argument was that even if you call it police power, forcing one group of people into a separate car inherently violates their equal status.
Obviously.
They argued that forced separation inherently stamped black citizens with a badge of inferiority. It was a public insult written directly into the state's legal code.
Which, again, seems completely undeniable. You don't pass a segregation law to make people feel equal.
But this is where we reach what is arguably the most shocking gaslighting piece of logic in the entire history of the Supreme Court.
What did he say?
Justice Brown dismissed the badge of inferiority argument entirely. He wrote that if enforced separation stamps the colored race with a badge of inferiority, it is not because of anything found in the act itself, but solely because the colored race chooses to put that construction upon it.
It's hard to even process that level of judicial denial. Let me think of an analogy.
Yeah, please.
That is like a city government locking someone out of the public library, throwing away the key, and when the postie complains, the mayor says, you only feel discriminated against because you're choosing to put a negative emotional construction on this locked door. The door isn't insulting you, your perception of the door is the problem.
Your locked door analogy captures the exact absurdity of the opinion. Brown completely divorced the text of the law from the lived reality of how the law operated in the real world.
Wow.
He created a legal fiction. In the eyes of the court, as long as the state said the separate cars were physically equal in quality, the act of separation itself did not violate the Constitution.
Equal but separate.
Yes. And with that legal fiction, the doctrine of separate but equal was officially born.
It is astounding. They take the 14th Amendment, which was written in blood after the bloodiest war in American history, specifically to guarantee equality, and they twist it into a pretzel to justify state-mandated segregation.
And just like in 1883, the court is once again taking the national consensus, the willingness of the North to tolerate and ignore Jim Crow in the South, and reading it into the Constitution, presenting it as an objective, natural, legal truth.
But just like in 1883, the ruling was not unanimous. The vote was 7-1. We have to return to our lone dissenter. Justice John Marshall Harlan, the former slaveholder from Kentucky, is once again the only voice in the room saying no.
And Harlan's dissent in Plessy is one of the most famous fiery documents in American legal history. He completely refused to play along with Justice Brown's legal fictions.
How does he dismantle the majority opinion this time around?
Well, he starts by rejecting the idea that the law was just a neutral exercise of police power for public comfort. He states bluntly that everyone, absolutely everyone, knew the real underlying purpose of the Separate Car Act.
Which was?
The purpose was not to keep white people out of black cars. The purpose was to keep black citizens out of white cars. He refused to pretend otherwise.
He calls out the elephant in the room. He's saying, we all live in the real world. We all know what this law is designed to do. Stop hiding behind technicalities like police power and social equality.
Precisely. And this is where he takes Albion Tourget's brilliant framing and immortalizes it in the Supreme Court record. Harlan wrote, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law."
Our Constitution is colorblind. It's such a powerful, definitive repudiation of what the rest of the court was doing.
It was a total rejection of the idea that the state could legally sort people by race for any reason. And Harlan didn't stop there. He looked ahead to the future consequences of this ruling and made a chillingly accurate prediction.
What did he predict?
He warned his fellow justices that their decision in Plessy would, in time, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case.
Whoa, okay. For context for you listening, the Dred Scott decision in 1857 was the case where the Supreme Court ruled that Black Americans could never be citizens, a decision that directly accelerated the country into the Civil War.
Exactly.
That is the ultimate insult you can throw at another Supreme Court justice. He is looking his colleagues in the eye and saying, history is going to remember this ruling as a profound, catastrophic moral failure on par with the absolute worst decision this court has ever made.
And he was entirely correct. The Plessy decision legitimized a system of racial apartheid in the United States that would dominate the next half-century.
It is an incredible moment of moral clarity. But we have to pause the narrative here, because this is a deep dive, and we don't just gloss over the uncomfortable parts of the sources. We've been painting Harlan as this visionary, this lone prophet of civil rights who saw the truth when everyone else was blinded by prejudice.
And he was remarkably, undeniably clear-sighted on the constitutional rights of Black Americans.
Yes, he was. But the dossier also highlights a massive, glaring contradiction in his Plessy dissent. In the very same beautiful, egalitarian opinion, where he declares the Constitution is colorblind and all citizens are equal, Harlan includes language that is deeply disparaging and xenophobic toward Chinese immigrants.
Yeah, it is a very jarring section to read. What's fascinating here is how he frames it. Harlan writes that the Chinese race is a race so different from our own that we do not permit those belonging to it to become citizens of the United States.
He just drops that in the middle of a civil rights defense. Like, what is he doing? Why include that?
He actually uses it as a rhetorical weapon against the majority.
How so?
He's essentially saying to his colleagues, you are allowing Chinese individuals who you don't even consider eligible for citizenship to ride in the white train cars, but you are forcing Black Americans who are full citizens and who literally fought to save the Union into segregated cars.
That is, wow, it completely burst the bubble of him being this flawless moral hero. He's using the era's widespread anti-Asian xenophobia, which, had just culminated in the Chinese Exclusion Act a few years prior as a debate tactic.
It forces us to confront the complexity of historical figures. It severely complicates the modern desire to paint these individuals as perfect, unblemished heroes. We want Harlan to be a 21st century egalitarian who just happened to be time traveling through the 1890s.
Right.
But he wasn't. He was a 19th century man with massive, glaring blind spots.
It's a reminder that history is profoundly messy. You can possess unique, prophetic clarity about one massive injustice and still blindly participate in another.
Very true.
It doesn't erase the brilliance of his defense of the 14th Amendment for Black Americans, but it means we have to view him as a complex, flawed human being, not just a marble statue.
Exactly. It reinforces the central theme of this entire historical deep dive. These justices were men of their moment. They were bound by the cultural frameworks of their time.
So let's step back and look at the long shadow these two cases cast over the country. Think about this timeline. You have the civil rights cases in 1883 and Plessy v. Ferguson in 1896, just 13 years apart. But those two decisions built a legal cage that lasted for generations.
They absolutely did. The sources stress that these specific rulings delayed civil rights progress for roughly 60 years.
60 years?
Yeah, they acted as the absolute, unquestioned governing law of American life until 1954.
Until Brown v. Board of Education.
Yes. In 1954, the Supreme Court in Brown finally overturned Plessy in the context of public schooling. And when they did, they essentially reached back through time, dusted off Justice Harlan's lone dissent, and adopted its substance as the new law of the land.
It took 60 years for the court to admit Harlan was right. That is a staggering amount of time for a country to live under a legal fiction. 60 years of people living under a system where the federal government couldn't stop private discrimination, and state governments were explicitly allowed to enforce public segregation.
And that leads to one of the most heavily debated, open questions in historical circles, which our sources highlight today.
What's the question?
It asks us to consider cause and effect. Did these Supreme Court rulings actually create Jim Crow? Or did they merely license and validate a segregation order that was already hardening across the South, regardless of what the court said?
Oh, that's a really tough question. Because as we discussed in the beginning, the national consensus had already given up on Reconstruction by the 1880s anyway. The culture was already moving backward, fast.
True. Historians debate how much power the court actually had to stop the tidal wave of segregationist laws. Some argue that even if the court had ruled the other way in Plessy, the southern states would have just found a different, more covert way to enforce Jim Crow.
Right.
And the federal government, exhausted as it was, wouldn't have had the political will to send troops back down to stop them anyway.
But the court's rulings still matter fundamentally, right? Like, even if they were just reflecting the culture, they gave that racist culture the ultimate stamp of legal approval.
Precisely. Regardless of whether they were the primary engine or just a symptom, the formal legal reasoning developed in these cases, so the state action doctrine from 1883 and the separate but equal fiction from 1896, provided the vital architectural support that allowed Jim Crow structures to legally exist and thrive.
They provided a shield.
Exactly. Segregationists could point to the Supreme Court of the United States and say, see? What we are doing is perfectly constitutional. The highest court in the land says this is fine. It gave a veneer of intellectual and legal legitimacy to profound injustice.
Okay, so as we wrap up this deep dive into the sources, let's summarize exactly what we've unpacked here today. Over a span of just 13 years, the Supreme Court took the 14th Amendment, which was a tool explicitly designed to dismantle racial hierarchy, and turned it inside out.
Yeah, totally inverted it.
First, in the 1883 civil rights cases, they stripped Congress of the power to stop private discrimination by inventing a strict state action requirement. Then, in 1896 with Plessy v. Ferguson, when faced with undeniable blatant state action, they gave states the green light to enforce segregation by inventing the psychological fiction of separate but equal.
They systematically closed every avenue for federal protection, leaving black citizens entirely at the mercy of hostile state governments and discriminatory private actors.
And it is so crucial to connect this history directly to the world you live in today, because understanding these cases shows us something critical about how the law actually operates in practice. It shows us how highly technical, totally neutral-sounding legal distinctions, like arguing over state action versus private action, or debating the difference between social equality and political equality, how those dry academic concepts can do enormous, devastating real-world work.
It serves as a permanent reminder to look closely at the cultural context of any court's decisions. When a court insists it is merely applying neutral, objective principles, we have to ask what cultural assumptions are being smuggled into those principles.
Right.
The justices of the 1880s and 1890s sincerely believed they were applying objective law, but history shows they were merely reading their era's prejudices into the Constitution.
Which brings me to a final thought I want to leave you, our listener, to mull over today. We know that Plessy and separate but equal were thankfully overturned in 1954. That specific architecture of segregation was dismantled. But here is the provocative detail that lingers. The state action doctrine that Justice Bradley created in the 1883 civil rights cases, that remains live constitutional law today.
It does. It is still a fundamental governing principle of American law that the Constitution generally only protects you from the government, not from private actors.
So think about that as you look at our modern society. We live in a world increasingly dominated not by the government, but by massive private corporations, sprawling tech platforms, and private infrastructure.
Right, massive private power.
If the Constitution only restrains the state, where else in modern life might a technical distinction between public and private action be hiding profound inequalities? Just like that architectural fortress we talked about at the beginning. The inspectors might look at the building and say, well, everything is technically fine here, no government rules are broken. But you have to ask yourself, are they looking at the actual lived reality of the people inside? Or are they just looking at the arbitrary lines they've drawn on the blueprints? Thank you so much for joining us for this deep dive into the source material. Keep questioning the sources around you, look closely at the foundations of the rules you live under, and we'll see you next time.